Good morning, everyone. Welcome to the offsite meeting of the California Fair Political Practices Commission. Let me begin by thanking Fresno State for hosting us here today and apologizing for being late. I can tell you have a beautiful campus. I just spent the last 45 minutes walking around. So great campus. Thank you again for having us. Let's go ahead and Ms. Contreras, would you please call the roll?
Commissioner Baker? We cannot hear you.
I will represent Commissioner Baker is present.
Commissioner Baker, go ahead and talk again.
Commissioner Ortiz? Commissioner Wilson? Commissioner Wood?
Present. There we go. This takes a minute.
I'm present too. Thank you, Ms. Contreras.
Apologies.
All right. So let me begin. Again, thank you, Fresno State, for hosting us. But we also are fortunate to be joined for the first time by our new colleague, Elsa Ortiz. So welcome, Ms. Ortiz. And I will now administer officially the oath of your office. Yep.
Yeah.
All right. So I, please state your name.
I, Elsa Ortiz, do solemnly swear that I will support and defend the Constitution of the United States and the Constitution of the State of California against all enemies, foreign and domestic, that I will bear true faith and allegiance to the Constitution of the United States and the Constitution of the State of California, that I take this obligation freely without any mental reservation, purpose, or evasion, and that I will well and faithfully discharge the duties upon which I'm about to enter.
Congratulations, Commissioner Ortiz. Welcome.
Thank you.
All right, and with that, let's go ahead and proceed to item 1. This is an opportunity for members of the public to provide comment for items not on today's agenda. Do we have any public comment under item 1?
Yes.
Steve?
Hello.
Hello?
Hello. Are you able to hear me?
Yes, we are. Please proceed.
Very good. This is Steve Petzold in Santa Clarita, California. I'd like to invite you to come join our beautiful campus at College of the Canyons located in Santa Clarita for one of your meetings. I'd like to get to meet you and show you around the campus they've built. I'm calling you today regarding some confusion regarding making sworn or anonymous complaints. Certainly, I need to understand whether on an anonymous complaint, whether I can check the progress of a complaint that is accepted through the portal. I have made all my complaints as sworn complaints, but recently the trustees at the College of the Canyons have adopted a special animus towards me since I have registered 7 complaints against 4 of the trustees that are currently in process. They refuse to consider placing me on the Citizens Bond Oversight Committee, although I'm eminently qualified. How that affects the FPPC is that what might be considered a minor violation really is a major one because it affects the actions of the trustees in discharging their duty and not putting on qualified candidates like myself. So I would like to, I'm planning to make an additional complaint, at least one, and I am hesitant to do that as a sworn complaint. I am requesting that I be allowed to do that as an anonymous complaint and that I be able to be notified of the status of the complaint as it is processed. So I don't think the guidelines are clear on your website as to what is available to a person whether they make an anonymous or a sworn complaint. And with that, I will ask you to perhaps check with Mr. Lindsay and have him comment. Thank you.
All right. Thank you, Mr. Petzold. And to your last point, I think we will have, we'll ask Mr. Lindsay to please give you a call and he can help perhaps clarify your options. So thank you, Mr. Petzold. Do we have any additional?
Thank you.
Thanks. Do we have any additional public comment on the telephone under item 1 for items not on today's agenda? Hearing none, I wanted to acknowledge that prior to the meeting, we did receive a written public comment under item 1. That's in the commissioner's binders. This is from Political Communications, Inc. And I wanted to make a comment at this time about that letter. One of the suggestions in the letter is to ensure that all of our public-facing materials, so the manuals, the various training tools that we maintain on our website, are consistent with the language of our regulations and the law. And so after receiving this public comment letter back in August, I did have a conversation with our general counsel, and Mr. Bainbridge has gone back through, he's looked at the manuals and ensured that they are consistent with the language of our regulation, as of course they should be. So I wanted the public and Mr. Montgomery and other commissioners to be aware of that. I have an additional aspect of this public comment that I want to discuss, but I'm going to hold that until the end for future agenda items. So with that, let's proceed to item 2, approval of the September 2023 commission meeting minutes. Do any commissioners have edits or comments to the minutes?
Abstain since I wasn't here at that meeting.
Completely understand. Any other edits, comments? All right, do we have a motion to approve the minutes?
Move the adoption of the minutes. Move the adoption of the and approval of the September minutes.
Second, that's all I was trying to do, sorry.
Any public comment on item 2? Ms. Contreras?
Commissioner Baker?
Aye. She's representing.
Oh.
A thumbs up.
Commissioner Wilson?
Aye.
That was
Well, Commissioner Wilson?
Aye.
Commissioner Wood? Chair Matich?
aye.
Mo-
Commissioner, for the record, Commissioner Ortiz is abstaining.
She abstained. Motion passes.
Now proceed to our consent calendar, items 3 through 5. Do any commissioners wish to pull any one of the matters from consent for separate discussion? Commissioner Baker, did you want to pull one of the items? We're having a hard time with your audio. We can't hear you, so if you could use your fingers to perhaps show us which item you would like pulled, we may have to resort to that. Item 3. Commissioner Baker has requested item 3 be pulled from consent. Do any other commissioners wish to pull an item from consent? Hearing and seeing none, let's proceed to the remaining consent calendar then, which are items 4 and 5. Is there any public comment on items 4 or 5?
And I would like 5.
You'd like to pull number 5? All right. Let's just go ahead and take items in order then, since each one will be considered separately. So let's just go back and start with item 3. Commissioner Baker asked that this item be pulled. Mr. Lindsay, why don't you go ahead and begin with any opening comments you have on item 3 in the matter of Kelly Schneider.
Chair of Commissioners, James Lindsay, Enforcement Chief. And I don't have any initial remarks on item 3, but we can certainly answer any questions that you have on this conflict of interest matter.
All right, thank you, Mr. Lindsay. So a couple questions I had. The first is in the language of the stipulation, there is a reference made to Ms. Schneider not reporting on her statement of economic interest her spouse's income.
That's correct.
And then there's also reference that she did amend her disclosure to include this information prior to the matter being referred to the Enforcement Division. Can you clarify for us whether that occurred before or after she had been contacted by the district attorney in this case?
I don't know for sure when she was contacted by the district attorney, but the general scenario is that there was, although not fully articulated in the stipulation, there was a whistleblower action, and the California State Auditor reached out, and in the process of that investigation, Ms. Schneider was alerted to the issues, the problem, and through that process, she amended her SEIs at that point. Whether or not the DA had been involved yet, I'm not sure. I don't think so, but I'm not 100% sure on that issue.
Thank you. And sticking with that for a moment, the facts state that she had been an employee. Ms. Schneider was an employee of the Earthquake Authority since 2016. Can you tell us whether the absence of her husband's income on her SEI was a continuing problem each year she filed her SEIs, or was it just one particular year?
It was a continuing problem until she was alerted through that investigation.
The stipulation on page 7, line 14, states that there's no evidence that Schneider acted with an intent to conceal or deceive. In light of the fact that Ms. Schneider consistently didn't report her spouse's income, and the facts before us indicate that she had received ethics training and had been in this position for some time, why wouldn't enforcement infer some intent to conceal by not consistently reporting your spouse's income and then entering into a contract with their employer?
We don't typically infer intent unless there's an indication in our investigation that someone is lacking cooperation or is purposefully, we have evidence that they've purposefully gone past what they know that they can do. In this instance, although she received ethics training, and anybody that prepares a Form 700, is alerted to the fact that you need to disclose your spouse's income. She indicated that she did not understand that, and she did amend it right away afterwards. So our belief, especially with all those actions occurring before we were even involved, our belief is that she wasn't intending to deceive, that she made a mistake, a fairly significant one that many others don't, but there wasn't any specific evidence that she was trying to evade.
So you wouldn't draw a conclusion that she consistently concealed her husband's income and then entered into a contract with his company, as you wouldn't infer any intentionality to that?
I don't infer any intentionality to it. I think that there was a series of mistakes, the same mistake, but assuming that mistake was made the first time legitimately, honestly, then it's not surprising, I guess, that she would make that mistake in multiple instances until she was specifically alerted that it was a mistake.
In this case, we have one count, and the only count we have is for the conflicts violation. But as we just discussed, she did not properly complete and disclose sources of income consistently on her SEIs. Why aren't we also charging her for the SEI violations?
In instances where the person has left office and the corrections were made before enforcement involvement, we generally do not charge those separately at that point.
Right. Those are my questions. Do other commissioners have questions of Mr. Lindsay on item 3? Commissioner Baker, do we have your audio working, hopefully?
I hope so.
Yes,
I hope you can hear me.
That's great.
Okay. And I apologize if my colleagues were raising their hand first. So I'm going to go out of order and also congratulate Commissioner Ortiz. Delighted to have an opportunity to work with her. And thank you to the Bulldogs for hosting us. I had the same questions that the chair had, but I also now have some opinions to express on it, and would invite you to share if you believe the opinion is incorrectly reached or without basis. To me, the Form 700 is unambiguous that your spouse's income is included. Number one. And the part of not charging the SEI failures, it sounds like there's a general policy that if there's an enforcement that's happened after the correction has been made, as a general policy, you don't charge them. In this instance, whether it was a whistleblower, the auditor, the DA, there were enforcement events that maybe notified her of the issue before she corrected it and before we started our enforcement matter. So I'm not sure that the general policy applies here. Can you address one? Is there anything ambiguous on the Form 700 about including your spouse's income? And on the second point, the applicability of your general policy.
I don't think that there's anything ambiguous about the Form 700, but she's not the first individual that we've come across that has made that mistake. In the end, we work with people to try to give them the benefit of the doubt if there's a basis to do so. In this instance, our contact with the respondent was positive in the sense of cooperation. And so it didn't, we used our discretion to not reach back into deep into the past before our involvement to attribute some sort of intent that we weren't specifically visualizing ourselves. With respect to the general policy, again, we try to look at these matters even when there is a violation that we are charging. We try to look at these matters consistently. In a vacuum, this failure under these particular circumstances due to the age and the fact that she was no longer in office, those wouldn't get charged. They would typically be something more along the lines of a warning letter. It could have been mentioned, and it is mentioned, but in order to charge and start assessing additional penalties for that, it felt a little much in this particular case.
Mr. Chair, if I just a moment, I just a follow up.
Go ahead and continue, and then I think Commissioner Wilson has questions after you.
Yes, please. Yes, thank you, Commissioner Wilson. I appreciate that the individual is cooperative. To me, that doesn't go to intent. And we have a professional who's been in this position, failed on multiple times to disclose something that was unambiguous on the Form 700, and actually approved the very contract that personally approved the very contract that is it issue here. And the rationale for approving the contract was that it was within budget and met all the requested scope of work, and the bidder team highly recommended. Very easy to accomplish if your spouse is the one whose contract you are approving. So I'm not usually a cynical person, and I bet my colleagues have heard that 100 times. But I reach a different conclusion about intent, or at least willful disregard, and find the policy of not charging the SEIs inapplicable here. I mean, I think of when people have a campaign violation and they're no longer in office, and I haven't seen that as a factor for not charging a account. And I welcome input from my colleagues, but I am not going to support this, and I would encourage us to charge FCI accounts. Thank you.
Thank you, Commissioner Baker. Commissioner Wilson.
Thank you, Chair Matich. Commissioner Baker covered some key points, but I wanted to kind of add an additional kind of question. In the stipulation, it referenced that $4,000 fine was consistent with comparable cases. But when we talk about comparable cases, did those comparable cases involve a contract that was entered into and signed by, in this case, Miss Snyder, as opposed to her not just having knowledge that her husband was, had income that was not reported? Because I think this case is somewhat distinguishable because in addition to not reporting the income, she was, according to the stipulation, involved in signing the actual contract that resulted in him receiving the income.
Sorry.
Mic's on at the same time, maybe.
Sorry, that hadn't been it seems like there's something going on with my microphone specifically. I don't feel like this is on at all. Is it on? Was a different decision. That matter was primarily 100. It is important to recognize in this particular case that although the DA did not choose ultimately to prosecute the matter criminally, we did not receive that written authorization to charge that count until right before the stipulation was entered into. We added the account because we felt like it was proper to do so, but we did not choose to charge it specifically as well because we didn't want the same conduct to be hit with two separate violations. It didn't seem like that was a proper thing to do, but we did include those facts in that analysis as well. With respect to the comparable, I think that the overall facts, I think, are very similar to this one, and I do think it's an appropriate comparable in terms of the violation amount.
Thank you. In terms of the comparable case, did it involve the head of an agency or a commission or a governmental entity signing the actual contract that was at issue?
No, it was just a vote on, I believe that she was a city council member. It was a vote on whether or not an issue relating to her husband's business, whether that should go forward or not.
Yeah, so I mean, that, I think it's debatable whether that's comparable, but I respect your professional opinion in that regard. And then the other question, just for the record, what was the amount of the actual contract that was issued by the Earthquake Authority?
The contract value was roughly $20,000, and there are some additional facts here that may be worth looking at. This was not just the respondent's decision. There was a 3-member panel. Although Ms. Schneider was the ultimate decision maker and the person that signed the contract, there were other people involved in this decision as well, and an agreement, as I understand it, to use Widener, the company that represented the financial interest. It's also important to know that the other signage, much of the other signage in that building was also done by this particular company. The company, as I understand it, was a pretty well-known, highly used sign maker. Ms. Schneider's husband was not involved in that particular aspect of the business. He's a welder. This signage didn't require welding. And her perception, as she indicated, was that she did not feel that because her husband's involvement was her husband was not involved in this particular project, that the conflict didn't, she didn't feel like there was a conflict, that he wasn't going to be making any more money, that his job wasn't affected, he wasn't doing anything on the project, and that company had actually done a lot of the work in that building for companies and agencies that were beyond the California Earthquake Authority, if that helps.
Questions, but in the interest of time, I'll defer. Well, I guess my last question would be, did Ms. Schneider receive any financial benefit as a result of this contract being issued?
No, nothing specific other than the fact that her husband gets paid by that company and she enjoys community property benefits from that income that comes in. But there was no specific income that went to her husband over this contract and therefore flowed to the respondent in question.
My last comment, Chair Matich, would be I tend to agree with Commissioner Baker that the amount of the fine should be higher than the amount, which is what, $4,000, I think. Thank you.
Thank you.
Wood?
Hi.
Hi.
Thanks for your work on this. Just to synthesize then what I'm hearing and maybe add a little something. So key facts I'm seeing: spouse was not on the Form 700, contract signed by the defendant, who was the ultimate decision maker, although not the sole decision maker, and the spouse gets the contract, although there's no direct financial benefit from the contract to the spouse, right? So in the comparable case, I didn't hear you say whether the spouse was on the Form 700. We know that the contract was not signed by the defendant and she was not the ultimate decision maker. Did the spouse own the cannabis business? So there was more of a direct financial benefit?
That's
okay.
correct.
So we have like a push and pull here, where like on the one hand here in the present case, Schneider had more control, and also, I mean, to put it cynically, had been hiding the link that enforcement would need to make the connection. On the other hand, the direct financial benefit was less, because in the comparable case, Ms. Perez had more of a direct financial benefit. So that helps me think about this. I could go either way, just for purposes of the commission. Like I could stick with this, and I could also float a little higher if people wanted to. I do think there's this separate issue that Commissioner Baker brought up that I think is important for us to think about, which is whether once she leaves office, there should be a general policy to not bring enforcement. Or it sounds like you're doing warning letters only, but I just wonder, like, I'm sorry, I'm not completing my thought, for the missing spousal information on the Form 700. Right, so it sounds like there's a general policy, once they're out of office, that we don't actually go after that sort of thing, or if we do, it's just a warning letter. We may just want to be really analytically clear on whether the public harm has ended at that point, and if not, what the appropriate response is. Because I think, I feel confused about why we don't go after it, but I also am confused about whether the public harm is ongoing. I'd have to really sit and think about that, so I'd love to hear your thoughts on that.
Yeah, I think that the reason that we treat leaving office in that fashion is the fact that there is no ongoing harm. And there was no ongoing harm in this case either. There just had been previous harm that was significant enough that we needed to enforce separately. But the statement of economic interest issue really isn't changed, at least in my mind. That occurred before. It was a mistake. It was corrected before we became involved in it, and doesn't necessarily have to be a policy or anything like that to not charge that. But that is typically how we handle that particular situation, especially in light of the huge number of referrals that we receive at FPPC. Including a lot of referrals that are pretty old And that's just one of the standards that we look at. Of course, we look at every case individually. We don't have a specific thing that we just have to do every single time. However, that is a factor. It's a big factor, and that is typically how we resolve that particular situation.
So there could be facts that make you think, no, there actually is an ongoing harm here. So for example, if CEA is charging more than they otherwise would be charging because they're giving contracts to insiders that aren't the best deal for the company or something, there could be an ongoing public economic harm, or there could be this kind of appearance of corruption harm that arises from the conflict of interest that is kind of hidden, or there could be an enforcement harm where the data that you all would need to actually make the connection to understand that there's a conflict of interest is missing. So there are potential harms here that can go past the time of the person being in office. But so I do think a blanket policy would not be good, but I just wanted to float some public harms out there just for the sake of the public too.
Yeah.
They're at least potential. I don't know whether, it sounds like you don't think they're happening in this case, but.
Yeah, I agree with everything that you said, and including the last one. I think that because whatever happened at this point, and that we are enforcing that, I don't think that there's a continued harm based upon the previous failure, especially now that it's been corrected and was corrected a long time ago.
Mr. Lindsay, my understanding was the policy with respect to not charging Form 700 violations was a little more nuanced. I agree for a leaving office generic violation without more that the policy has been to issue warning letters, right? My understanding had always been that an SEI violation coupled with a conflicts violation was not treated through the warning letter process, but instead was capable, at least, and eligible, if you will, to continue being charged. And I wonder if what your reaction to that nuance is, because I think it's an important nuance.
Yeah, and I think there's a lot of nuances, to be honest with you, including the fact that we're negotiating here with an individual that is no longer in office. $4,000 is a lot of money to a lot of individuals versus maybe if you were dealing with someone who's differently situated in office or a public entity and whatnot. You do reach a point sometimes with additional counts and additional money that you can't settle that case any longer. And then you don't get the benefit of having a stipulation out there to educate the public after the fact, but still educate the public. You sometimes end up going forward with not being able to get anything done at all. Maybe this individual ends up defaulting. Maybe you spend a lot of time going to hearing over an extra $1,000 or something like that as well. So there's also a lot of factors that we have to look at just generally in enforcement and look at the entirety of a situation. This situation, we have an individual that made a mistake. She's taking responsibility. I think for the conflict of interest, it is in line with what we've done and what occurred in this case. The statement of economic interest, yes, it could have been separately charged. It's not, I don't think, what we would normally do, and I think that in this instance, it would have probably pushed this into a different realm of what we were going to be able to do with the case.
With respect to the public harm, one thing that strikes me here is under Government Code 1090, my recollection is that disgorgement is one of the remedies for pursuing 1090. We don't have the authority to do it, but that could have been a remedy. Mm-hmm. And of course, that's so that people don't profit off of a decision that was based on a conflict. But Wiedner didn't have to give back. They didn't disgorge the money in this circumstance, did they? They continued to profit even though this contract was entered into unlawfully, right?
Yeah, the district attorney did not rise to the level of them even pushing the matter forward. They made a choice not to. I think it's important to note also when you think of disgorgement of profit, for our standpoint, we're dealing with the respondent specifically. she didn't profit $20,000 from this particular matter. I mean, perhaps, and neither did Widener. I mean, it cost money to make signs and whatnot. I mean, the money that was profit, even to someone that's not the respondent, was less than $4,000, I'm sure.
And again, you may have answered this earlier, but I'm curious. There are actually two separate conflict statutes that were violated here. So, but we're only charging under one. So not only did we not charge the SEIs, but we could have actually charged her under both the PRA conflict provisions and 1090. So why didn't we do that?
Oh, we didn't do it because the value of the contract and the value of what the value of the decision, so to speak, to the respondent was not appropriate, in our opinion, to double up on that same conduct and make it, say, an $8,000 violation when it was only a $20,000 contract that, you know, in reality, although wrong, it was not commensurate in our mind with what was received from that contract.
All right. Commissioner Baker, did you have any additional comments?
Thank you. I appreciate it, and the good questions from our colleagues and response. I will just say for me again, I will not be supporting this. I believe we should send it back with instruction to include SEI counts. That's part of the taking responsibility for the error on multiple SEIs on something that's not ambiguous. I don't see in the four corners of the document why the DA didn't choose criminal. There could be many reasons. I don't know that Chief Lindsay, you mentioned that it didn't rise to the level of seeking either disgorgement or further action, and perhaps the DA's office thought we were the ones to take more appropriate action. I welcome wants to elaborate on that. I just didn't see it in the four corners why the DA didn't criminally charge. But I am not comfortable with the stipulation. I believe there's too many factors that show either, again, willful negligence, gross negligence, if not intentionality. And an appropriate stipulation would include SEI counts. And if they can't agree to that, then there's a process for what happens. And we go from there. Thank you. In fact, I will move to reject the stipulation with instructions that SEI counts be included and a re-examination of the intentionality.
Commissioner Baker, before we call for a second on that, Commissioner Wilson actually has an additional comment. So we're going to pause and come back to the motion.
Thank you.
Okay. Thank you, Chair Matich. First of all, Mr. Lindsay, or Chief Lindsay, I appreciate all the hard work that you've put in and come up to speed so quickly on a lot of these nuanced questions that we have. But kind of as a follow-up to the whole SEI count issue, and while this isn't in the four corners of the stipulation, you made reference to Ms. Snyder's income and whether maybe I misunderstood you, but whether she could afford to pay for a fine if it was higher. How could you elaborate on that? Because how do we even know whether she has the resources? Oh, you might.
What I do know is that negotiations were not easy in the sense that when you are negotiating with private individuals, that's a significant matter. My feeling about this is that if the instruction is to go back, that you won't be seeing this matter anytime real soon, and it's old activity. I think that this matter is it's a 2019 case, but it relates to 2018 activity. We don't have a lot of time at this point to further negotiate. We'd have to try to do a quick PC report, maybe go to trial. I don't know for sure that we can't renegotiate, but we worked pretty hard to get this matter, and that's not uncommon with individuals. And so I would it would be wrong of me not to caution the commission that these aren't easy decisions to go back with people and try to renegotiate these things. My guess is that there will be significant pushback. If that's what the commission wants to do, of course you have the right to do that, but I don't think it's going to be, we're going to add these counts and this is going to be some extra money and she's just going to sign it. My guess is that that's not how this typically works, and it's probably not going to work in this particular instance.
My last comment, I can speak for myself. I don't think we should be running from a case because we're concerned about pushback. And if someone has violated the act or violated the law, that's something we should seriously consider, regardless of whether we'll be able to collect on the fine, because as Commissioner Baker pointed out, there is a process when that in fact is the case. So that's my last comment, but thank you very much.
Mr. Lindsay, this commission repeatedly has said that conflicts are among the most egregious in our mind types of violations. And I think there's from my standpoint, I'm not quite there yet at believing there wasn't at least some, as Commissioner Baker expresses it, willful neglect going on here. I mean, I can't not see that from the fact pattern. At the same time, I would express it a little differently. I think the question for us is whatever incremental increase we may get, is the value of that worth the significant, probably, amount of resources our staff's going to have to expend in this case? And so do we take that approach in this case, or do we provide you forward-looking guidance on how we want these things to be handled in the future, so that we don't end up back here again? And it's a long windup for a question, which is, if we were to approve this, then it's eligible to be used as a comparable, and that's where I'm stuck and not happy about wanting to approve this. But can we instruct you not to use this as a comparable for conflicts cases in the future? Is there, and if, we could ask Mr. Bainbridge or Ms. West if they know offhand, but it seems to me that may be one approach here, is we don't want this ever used as a comparable. Does anybody know? Can we do that?
My understanding is that, yes, we can not use this as a comparable. The facts are different in every case, so you tend to choose which ones you think are most appropriate. And we can certainly receive the direction that in a case such as this, that we want these things charged if at all possible, the underlying SEI violation. And yeah, I can definitely hear that direction moving forward if that's the direction that the commission would like to go.
One of the things that you mentioned that kind of got me thinking is this idea of stopping enforcing after a certain amount of time, but there is no specific definition of how long that time is. Is there a statute of limitations? Like in campaign reports, after, 4 years or something, the campaign reports are gone. So maybe that's something that we should look at establishing some statute of limitations on this this Form 700.
The Form 700 would be applicable to our standard statute of limitations, which is 5 years. 5 years, yes, and that's why I mentioned that this is 2018 activity, and so we are, we're at the very close to the end here.
I'm pretty uncomfortable with the idea of voting for something that we know is going to be a bad thing to refer to later. I don't like that. I wonder if we could add language in here about how we're up at the statute of limitations on the Form 700 violation, in which case then it's easy to distinguish from future SEI violations that are timely caught or timely negotiated. I don't know. I just, I think because it was cured before it came to the commission, maybe that's a little something. I am kind of with Commissioner Baker that I'm a little skeptical. Like there's a version of this that's really ugly. But at the same time, I'm sympathetic to the idea that like we have been on this big enforcement push and we're being told very plainly that this is going to slow things down. And so I'm hearing it all. And I'm wondering if there's a way to insert language here that both parties, that we can agree to and that the defendant would agree to, that would then make this something we don't have to worry about giving an instruction already to not refer to it later.
So my understanding is that to add language to the stipulation, we would have to reject it and direct Mr. Lindsay to go back and renegotiate the language. So the question I have for you then is, Commissioner Baker has expressed that she wants a higher fine and additional counts. You're saying that you would like to reject it and have new language in. Where are you at with respect to the counts and the amount? Because I think if we're going to reject it, we ought to be really clear to Mr. Lindsay what it is that we want back.
I think it would be fine to charge it as a count, but I do think it would need to be a pretty low penalty because of the mitigating circumstances that he's told us about. And so that, but then also, like, I don't know what the comparables are on this kind of things. It sounds like it's mostly warning letters, And so there might not be comparables when something's this old and it's just an SEI. I'm sorry, I'm not as familiar with the kind of comparable landscape out there.
Yeah, I suspect we can find a comparable or two.
Actually, Commissioner Wood brings up a point that because it wasn't a part of the stipulation, we need to understand too that the SEIs were filed before the actions as well. And so it's possible that some of those counts are already beyond 5 years. Now, there were amendments to those SEIs, which arguably would create a new statute. There's certainly legal theories that would support that, but I can't promise you that the SEI violations are even able to be charged at this point.
Well, I know, but I'm going to ask a clarifying question about that first. 2017 SEI, that would be within the statute, right?
17 SEI? No.
2018?
Probably not, no, because it would have been due, if it was filed timely, it would have been due in April of 2018. It's more than 5 years.
So we're talking about 2019 is the only SEI left standing, essentially. 2020, she left the position, right? So you could go after that, I suppose, but that's going to be...
Yeah, that's even right, and that's after the activity in question now, which seems, I don't know,
So the bang for our buck is one SEI violation, likely, that we think we have a statute of limitations that could fit.
Yes, unless we made the legal argument that the amendments to previous SEIs somehow extended the statute of limitations, but I can't stand on that. It's a theory that's coming into my head right now, but that's it.
That's okay. Commissioner Baker.
Thank you. Appreciate again the great comments. I know the hard work of our enforcement team working on this matter, especially their difficulties to negotiate. I just want to add 2 points. One, I didn't express a concern about the fine because I know it's on the higher end. I apologize if I was blurry on that. I expressed great skepticism on the intentionality and that it was just some mistake. A great concern is that there's zero accountability for SDI violations because none of them are charged, even the ones that may still be subject to the statute of limitations. And for that reason, I believe it is appropriate to reject and give direction to not what specifically to charge, but to investigate and pursue what can be charged with the SCI counts see what can be negotiated. And if it needs to come back to us where we are the ones who deliberate on the appropriateness of the facts, we may learn more about this. And that is something I'm willing to do with an open mind. But I think first, I'm not comfortable supporting a stipulation that we wouldn't want as a comparable, and not even knowing the process for how we make sure it doesn't become a comparable 10 years from now. With that, I've been given generous time to express my views, and I appreciate those of our colleagues as well. And now I do not hear.
I don't know if you can hear me. I just in support of James so that you guys have the full picture. Enforcement has mechanisms already in place to ensure that comparables that the commission has gone a different direction that are no longer used in the future. So they have a comp chart that they make notes on. They also have an electronic database that they make notes on the cases themselves. So they have a lot of mechanisms in place to ensure that the commission's direction is followed. So I would relieve your minds about that part, that is something that they always want to get it right because they would like you guys to just look at the consent calendar and go, looks great. So they're very motivated to make sure that they take your comments and memorialize them so everybody's using them.
Thank you for that. So we have a motion on the table by Commissioner Baker to reject the stipulation with direction to include, if possible, the SEI counts. Is that correct, Commissioner Baker? All right. I don't know if I need to make a friendly amendment, but in addition to that instruction, I think that, Mr. Lindsay, that there's additional facts that are not presented in this iteration of the stipulation that we've talked about today, some of which you've told us now for the first time about that weren't in the stip, that I think could support the statement about no intent to conceal, and make it a little easier for the commission to understand where staff's coming from with respect to that conclusion. So I think you should include that as well. Commissioner Baker, do you have any objection to that being part of the instruction as well?
I would accept that. I think it falls in the look again at the intentionality factors that I had mentioned in the original motion, and it seems very consistent. So yes, thank you.
Any other commissioner comments on the motion? Commissioner Wood?
I would also welcome the mention of the statute of limitations, just so it can be a clean comparable in the future. If that's okay with Commissioner Baker, I don't know if it is.
I'm trying to figure out what the contours of the motion will be before we express it.
I don't know how you feel about that, Commissioner Baker.
I thank you, Chair. The Chair. I think what I heard you mentioning was that we're coming to this conclusion because we're close to the statute of limitations, and therefore that's why we don't really like it as a comparable. Maybe I need clarification on the point. My initial reaction just internally was, we've confronted being close to the statute of limitations many times. That's part of the factors. I'm not sure that it goes in a stipulation, but perhaps I need clarification. I appreciate the good creative ideas.
Just that I was kind of doing the math in my head and realized that the SEI violation that caused the harm, the most proximate one, was already the statute had already run, and so like I had already figured that out when I said that. But you're right. I think I phrased it as like close to the statute of limitations or something. Yeah.
And perhaps that's part of the compliance with the motion is to go look at, as the chair articulated, what SEI counts are available and appropriate. It's possible that amendments triggered a new statute of limitations. I've heard that argument before, not before the commission, but in professional settings. So I think that would be my response. Thank you.
So for purposes of trying to state the motion clearly at this point with everyone's input, My understanding, Commissioner Baker, is that your motion is to reject the stipulation with instructions that staff add additional counts where possible for violations of the statement of economic interest. To the extent that there are SEIs for which the information regarding the spouse's income was not included, but are not being charged because of statute of limitations reasons, that be stated clearly in the stipulation, and that we add language specifically identifying the facts and the basis for staff's conclusion that there was no intent to violate the conflicts rules here.
Once again, the chair has stated it well. So thank you. That is appropriate contours. I appreciate it.
Is there any public comment on item 3? All right, with that, Ms. Contreras.
Commissioner Baker?
I'm not sure I heard who the second was, but aye on the motion.
Commissioner Wilson?
Aye.
Commissioner Wood? Got it? The motion passes.
All right, our next item, item number 4, in the matter of the City of Garden Grove and Scott Stiles. Mr. Lindsay, not going anywhere yet. Did you have, and I know nobody specifically pulled this, but since we're just taking them one at a time, did you have any comments or things you wanted to point out with respect to this stipulation?
Nothing substantive, but I will say that to remind the commission, we had a discussion at the last commission meeting regarding trying to make mailers, other types of media, print and otherwise, exhibits to our stipulation. Negotiated fully signed before the last. There was no attempt to make an exhibit here. However, successfully, respondents in this allow us to present that mailer, and I had it with me today. Okay, thank you. And I just wanted to, going forward, I wanted you to be aware that that is on the radar, and that's the reason why that wasn't attached as an exhibit in this particular matter.
Okay.
But we will do endeavor in all instances in the future to try to get that kind of material as exhibits to the stipulation.
Appreciate that, Mr. Lindsay. Thank you. Did any commissioners have any comments with respect to item 4? All right, hearing and seeing none. Mr. Lindsay?
Yeah, I mean, this is more of a technicality, and I know we have to stay within the 4 corners of the stipulation, but there's a reference to that Mr. Stiles is no longer works for Garden Grove, and I know I can't elaborate beyond that, but if we're going to go down that path and state that he's no longer with a particular city, I think that opens the door for further discussion, because it implies that, oh, well, maybe he's retired or he's not working in city government anywhere else. So I think in the future, if we go down that path, then we should specify, well, what is he doing? Okay, because, well, I can't speak to the 4 corners. That's an issue that I think would be addressed if it's further elaborated on.
Okay, we'll try to put current employment in those instances when we can.
And if there's no reference to the fact that he no longer works for the city of Garden Grove, and that's all it said, that's one thing. But when there's a statement made that, well, he's no longer working, it begs the question, well, what is he doing? That's all. So thank you.
Thank you, Commissioner Wilson. Any additional comments for Mr. Lindsay on this item? Hearing and seeing none, I would move to approve the stipulation in item 4. Is there a second? Is there any public comment on item 4? Hearing and seeing none. Ms. Contreras.
Baker,
Aye.
Commissioner Ortiz, Commissioner Wilson, Commissioner Wood, Chair Matich. Motion passes.
All right, thank you. Thank you, Mr. Lindsay. All right, next up is item 5. This is an item that comes before us from our staff. They are our education and external affairs unit and legal division. This is part of their ordinary process of updating campaign forms to conform with changes in the law that were adopted by the legislature and any regulatory changes that we adopted. That's the issue before us today. Do we approve the forms or not? So with us, Ms. Hackert, good morning.
Morning, Chair and Commission. Yes, this is the updates to the Form 410 for Statement of Organization for recipient committees. These updates are in response to Commission Regulation 18410, which was regarding adding bank signers or those who had access to bank account onto the Form 410, and then additional changes were made in response to public comment, in response to AB 909, adding email addresses for treasurers and principal officers to the form. And then we also worked concurrently with our sister agency, Secretary of State, to make sure that all of the changes would conform to their existing Cal Access system.
Thank you, Ms. Hackert. Did any commissioners have questions for Ms. Hackert on the revisions that are being proposed to the Form 410? Commissioner Ortiz?
Thank you for the report. I have kind of clarification. I need to understand some stuff. On the proposed 410, there's, and according to your memo, the green highlighted areas, are those the new ones that are added to the 410?
The green and the yellow are changes to the existing Form 410. So the yellow highlight indicates the changes that we pre-notice as a part of public comment. And then the green is the changes we made in response to the public comment.
Okay. So according to your memo, the provision of AB 909 require email addresses for treasurer and principal officers is effective now. What is the effective date? This or something before?
AB 909 was a part of a prior legislative cycle, and a lot of the provisions in AB 909 take effect with the certification of CARS, the Cal Access Replacement System with Secretary of State. But the one provision that takes effect now that we're adding into the form that we learned from public comment is that email address part, and that's in the current statute that we have in Act right now.
So it's not in effect right now, will be in effect on January 1st, 2024?
Email addresses are in effect now. It was something that we did not catch initially with my time, have it initially, so now we're adding it to the form. And with any changes to the form, we have to make sure that it works with the current system with Secretary of State. So we worked with their system to make sure that they could accommodate this additional information, which it can.
So what happens if a candidate or elected official, treasurer who filled out the previously, and there was no, as I understand, no space for the email address until now? So what happens to those previous?
File an amendment. They would include this information on the Form 410. And previously, there is a field that's required for the committee email address. So the committee email address field has been there and has been present on the form. But going forward now with the one that will be, if it's approved by the commission, the principal officers and the treasurer and assistant treasurer will be required to include their email address. And we would be putting education out there regarding this new requirement.
So previous report, previous 410 forms filed that did not include the email addresses of the treasurer and the other things, those committees will have to file amendments now, or what?
Dave Bainbridge, General Counsel. I'll answer that one. No, they're not required to file amendment. It's just going forward.
Going forward,
If they
that's-
complete this form, either because they're a new committee or they're filing an amendment, they will then need to include that information per the statute.
Okay, but see, in your memo, you say, for committees existing prior to January 1st, 2024, the statement organization shall be amended to include the names. Oh, no, those are the bank records, not the email thing. So, you explain that? Is that what it is? Amendments, if they do not include the names, the bank records proposal that we're doing now?
Yeah.
Okay.
So you have it exactly right. By this regulation that the commission passed last year, that is slated to go into effect on January 1, they would have 6 months to go back and file an amended 410 to provide that information. There's no similar requirement in the law requiring that they provide their emails.
Great, thank you.
Cool. Any other questions or comments on item 5? All right. Well, I would just take a moment before we take action on this and hear public comment to acknowledge that we have received a number of public comments on this. They track very much the same debate and discussion that we had a year ago regarding privacy issues that unfortunately campaigns and treasurers, et cetera, face today. And as we talked about a year ago, that derives from a statutory requirement that bank account numbers primarily are available to the public upon request without redaction. They are redacted electronically, but if somebody wanted to come in and get a copy of the 410 in paper, they would have access to a bank account number. That, for this commission, has not struck us as wise policy, and that's why not once, but twice, we have gone to the legislature and tried to get that law changed to allow for redaction, because you shouldn't be handing out bank account numbers. And that is the only reason why we delayed the effective date of the additional regulation that we put in place last year to give enforcement additional tools to be efficient in resolving particularly old cases that we have been encouraging them to focus on. And so we delayed it for a year. We went to the legislature last year again, trying to get this problem solved, and the bill did not succeed. And so at this point, I feel like we have been a good faith partner with the regulated community to try and achieve this regulatory or this statutory change that's necessary to really address their concerns. Unfortunately, the members of the regulated community who have commented on this proposal today, which is simply about updating the forms, submitted nothing in support of either legislative proposal, either back in 2020 or last year. And so while I think the commission should continue to support that legislation, my view is that that is not a basis for continuing to deprive our enforcement division of a tool that this commission last year deliberated over and decided was wise policy to give to our enforcement division. So that's my view, and that is why I am moving that we approve the updated 410 as presented by staff. With that, is there a second?
But can I add that we hopefully will continue to pursue the legislation to take care of this concern that's raised by several people?
I agree with that. Yep. Commissioner Wilson?
Second.
I know that this has been covered before, but for the record, if Mr. Bainbridge, our general counsel, could explain why we don't have the discretionary authority to not release those bank records. I mean, that to me is common sense. You don't just hand out bank records because someone's come in and made that request. But I know that's been covered before. If you could elaborate on that, that'd be helpful.
Sure. Yeah, the requirement that the forms be provided without redactions is in statute.
All right, so we have a motion, we have a second. Is there any public comment?
Hi, I have a public comment.
Proceed.
Can you hear me okay?
Yes.
Okay. Hi, thank you. This is Casey Jenkins. I'm chair of the Regulatory Committee for the California Political Attorneys Association. Thank you all, commissioners, for considering our comments and our request to delay the implementation date. We do feel very strongly about this due to the prevalence of fraud that our committees are seeing in today's day and age. I wanted to point out, though, we also recognize that CPAA as an organization needs to put effort into a legislative fix as well to fix the statute. So one of our members currently is in discussion with a legislator about authoring legislation on this topic for next year. So we're willing to do what we can with this. As are you guys, we were disappointed that SB 888 didn't make it through the legislature last year. So even just a 1-year delay would be helpful. And I wanted to highlight how the prevalence of fraud on campaign bank accounts. Our fraud has had our checks intercepted in the mail. The name and signature of the signers are lifted off of them. Once an instance like this happens, it is onerous to get it fixed, between tracking down the fraudulent checks, changing the bank account number, and updating it everywhere that it needs to be updated. We just think having the name of the signers directly on the 410s just make instances like these more prevalent and even easier. When they readily have this information, they need to commit frauds. They may not even need to intercept a check in the mail because the name of our bank and the account numbers are already on the 410. As we know, the Secretary of State does not redact them. And now if the signers are out there too, that's everything they need to just make a check, to make a fraudulent check on our account. And so given we want to do everything we can to protect our clients and our committee's financial information. So again, thank you for considering our comments, and we hope that you would consider delaying the regulation at least a year. Thank you.
Thank you. Is there any additional public comment? And seeing none, just want to clarify for the benefit of the commission and the public and public commenters that my understanding from our general counsel is the request to simply continue to delay this regulation until, if ever, we get legislation to redact it isn't a possibility legally. That if we were to indulge that, what we would have to do today is disapprove the forms and then schedule next month a vote to rescind the regulation. So the regulation would simply go, this portion of it would simply go away, and we would have to then go through the process of pre-noticing again and relitigating whether or not we want the additional signers. So to me, that's just an additional reason why we can't accommodate this request today. So I just want, Mr. Bainbridge, is that correct?
That's correct. We would have to essentially amend the regulation just like we would any other regulation. So it'd be a few-month process with the Office of Administrative Law.
With that, we have a motion, we have a second, we've taken public comment. Ms. Contreras?
Commissioner Baker?
Aye.
Commissioner Ortiz? Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Matich?
Aye.
Motion passes.
Thank you. All right, we'll now proceed to item 6, receiving an update on the new LaVine Act, regulations and advice and issues that the legal division has seen since that law went into effect. And with us for that presentation is our general counsel, Mr. Bainbridge.
Good morning again. I prepared a memo here that at the instruction of the commission when we adopted the regulations for section 84308, I believe it was in May, they asked that we come back with a report occasionally, just giving an update on what's going on with all of our efforts regarding section 84308, the LaVine Act. So I won't go through this memo, but we have collected the advice letters we've issued on this topic. We've also put in some email advice that we've given that's just sort of points of interest we thought might be interesting to the public to see what advice we've given. You'll note, as we predicted, we've seen quite an increase in the amount of advice requests we receive on this topic. I've got the specific numbers here in the report. We went from 3 letters in 20 and 21 all the way up to, so far this year, we've issued 8 advice letters, and anticipate seeing a few more before the end of the year. Same with the email advice. We've seen quite an uptick in the number of email advice requests about Section 84308, as you would expect when a law expands to cover a lot more people. And then I really wanted to highlight some of our work from the educational standpoint. We have Kevin Cornwall, who was the attorney who worked on these regulations, then got to put together a training for it. And that training is done. We've given it to staff, and now we're going to make it available to the public. We'll be hosting a webinar on November 1st. Anyone who's interested can sign up for the webinar, join online and get the training. It's a PowerPoint slide. And we plan to have additional trainings, assuming there's demand for it. So if you go to our website, our training and outreach page, I've got the URL here on the report. Anyone who is interested can sign up for that training. I think it's about a 2-hour training in it, and it gives a good overview of what 84308 requires, and it looks at it from the perspective of both the official who has to comply with it, as well as the party or participant who is required to comply with it. Similarly, Mr. Cornwall, working with our education group, has also created a couple guides. And one guide is for officials and how they can comply, and the other guide is for parties or participants who will also be subject to the law. So depending on where someone is in the process and what their role is, they have a guide that's designed for them. And then we also, through the past year, have identified some additional regulatory amendments that we think would be helpful. We'll be bringing those in the coming year, and we'll have more on that next month on what the regulatory proposals will be for next year.
Thank you, Mr. Bainbridge. Any questions for Mr. Bainbridge on our experience thus far with the LaVine Act regulations? All right, Mr. Bainbridge, I have one question for you. I note that in July we issued advice to Adrienne Granda regarding a strong mayor question. And that is the issue of the applicability of our regulations to strong mayor forms of local government came up during the regulatory process. And we were trying to decide whether that was something that we could fit into the regulations. We decided it was better approached through the advice giving function. Having given this advice letter, do you see any room or need to do a regulation on strong mayor issues, or are you comfortable continuing to do this through the advice letter process?
We haven't received another advice request on this topic, which makes me think this letter probably has satisfied I believe there's 5 jurisdictions in the state that have a strong mayor type setup. There's case law on the issue, and the advice may depend on what their ordinance says, their strong mayor ordinance says anyway. So that's a long way of saying I don't think a regulation is necessary. I think handling it through the advice function as it comes about is probably the best way to deal with it.
Appreciate that. All right, this is an informational item that doesn't require a vote, but is there any public comment on item 6? This is Mr. Bainbridge's update on Government Code 84308, LaVine Act. All right, thank you very much, Mr. Bainbridge. Moving right along, let's move to item 7. This is presented to us for approval. A new regulation to delegate commission authority to the executive director for settlement of an order of monetary penalties. And I believe we have Ms. Harrison, senior counsel in the legal division, appearing remotely.
Good morning.
I hear her. Good morning, Ms. Harrison.
You can hear me? I hope you can see me as well.
And now we can. That's great.
All right. Good morning.
Good
I'm
morning.
Karen Harrison, Senior Commission Counsel with the Legal Division. I am presenting proposed regulation 18318 for adoption. As a brief background, part of the Commission's focus on efficient and effective collection procedures, staff made an April presentation, and at that time identified the need for a regulation delegating authority from the Commission to the Executive Director to settle collection actions. In August, the Commission considered and provided comments on proposed regulation 18318, which is now before you for adoption. No changes to the proposed regulation were requested at that time, and there's been no public comment. As a framework, Collection issues for the commission largely involve default judgments where there's been no or little participation on the part of the respondent/debtor. And state laws and policies mandate that an agency uses a cost-benefit allocation of resources in collection actions. I'll give a quick summary of Regulation 18318 and then take some questions. So briefly, it delegates authority to the executive director to enter into a settlement agreement in full satisfaction of an order for monetary penalties, and it requires the executive director to report the executed settlement to the commission. The commission's role in the process is to monitor the executive director's actions and provide feedback for future agreement, but the commission does not approve or vote on the individual settlement agreement. Under the proposed regulation, the executive director has the authority to enter into a settlement agreement where the following are met. It's a final order, not subject to any further judicial review. 3 collection demand letters have been sent, and as a part of this demand process, a skip trace is done at that time under commission collection policies. Number 3, as far as the items that need to be met, staff needs to have made reasonable collection efforts. And this means that staff has sought offsets with other state agencies, such as Franchise Tax Board. And if legally permissible, staff has sought appropriate judgment enforcement methods, such as a real property lien, personal property lien, wage garnishment, bank levy. Lastly, the executive director must determine that the settlement is appropriate, considering 4 factors. The executive director must consider if the settlement amount exceeds the amount likely to be collected in a reasonable time. Number 2, the debtor's ability to satisfy the full debt or a greater amount in a reasonable time. And here the executive director is considering the debtor's assets, income, and prospects for either. Number 3, the amount of the debt attributable to interest on the original penalty amount. And lastly, the executive director must consider the severity and type of violation for which the penalties were assessed. In subdivision B in the proposed regulation, it's required that the executive director include a brief description in the settlement agreement of staff's reasonable collection efforts and the factors that justified the settlement agreement. And this is reported to the commission after its execution. As mentioned previously, the commission's role is to monitor the process and provide direction for future settlements. The proposed regulation sets up a process to ensure that settlements are entered into in a cost-effective, timely manner following the consideration of significant factors and provides for commission feedback on the process. Are there any questions?
Ms. Harrison. Thank you, Ms. Harrison. I had one suggestion for a very minor tweak to the regulation. You're correct. The regulation does require the executive director to report to the commission when she executes a settlement agreement. It doesn't specifically say when. I think we've talked about it being part of the executive director's monthly reports to the commission as a sensible way of accomplishing that. And so my proposal would be on page 2 of the proposed regulation, line 8, after the word execution, that the sentence, "that report shall be made at the next commission meeting," period, be inserted. Do you see, in particular, Ms. West, we're just simply saying what we've talked about previously about the timing of that report. Do you have any major objections to that?
I have no objections, but I'm going to defer to the executive director and Mr. Bainbridge for any comments they might have on that timing.
I would say we would just want, this is Galena West, Executive Director, we would just want to make sure that we put some language to where it's feasible, so it's like within the posting deadline kind of thing, or, yeah.
That's implied.
Okay, if it's implied, then I've said it out loud now, so just so I'm not revising agendas, that's,
all right.
Other than that, I don't have an objection.
All right. That was my comment. That was my suggestion. Do other commissioners have comments or suggestions? Commissioner Ortiz.
Throughout the meeting today, I've heard this statement, and I would like to understand it, that a person who has been found that he or she violated and a fine has been imposed, one of the issues that you look at is the ability of that person to pay that fine. Is that correct?
Not generally. So enforcement has its criteria in the regulation, and ability to pay is not one of them. So this would be in a situation, all the settlements that you saw today, the person has already paid. They've already given their cashier's check or whatever means to where the money is already in our hand, because the commission isn't even presented a settlement unless the money is in enforcement's hands already. The cases that we're talking about you haven't seen yet. They're called defaults. So this is when someone has either decided not to participate in the process at all, or they just completely disagree and don't want to admit to any violations. And so then enforcement brings that to the commission and says, we cannot get them to settle. They don't want a hearing. So we want to do this higher fine and try to pursue it through our collections. And then that goes over to the administrative process, and we try to get the money that way.
I thought Ms. Harrison mentioned something about looking at the ability.
Right. So then once it's in our collections process, then as one of the considerations that I would be able to look at is when we're doing that cost best benefit analysis on if we're going to be able to get some of the money back, or if this is a good settlement, that would be one of the factors that I would look at way down far down the line.
Because I keep wondering, okay, you look at the potential to pay. How are you going to decide? Is that your own personal, your subjective or objective decision as to, okay, that person can only, let's say the fine is $10,000, or that person can only pay $3,000. I mean, you will have to explain that, or what?
Generally, what I've seen is that they would we would send them a financial information inquiry to where they say, we want to settle. It's a 20-year-old fine. I want to get this off of the books. You have a lien on my house. And so then we would send them financial information requests, and we would get their financial information, and we would validate their claims of not being able to pay. And then that would just be one of the considerations of the four, that we would use actual facts. I'm not much of a believer of what people tell me, so I would rather see it in some paperwork. And so we would get some information before we make that determination.
Yeah, thank you.
There are questions or comments from the commissioners? All right, then I'm going to move approval of the proposed regulation in item 7 with the following change. In regulation 18318 subdivision B, immediately after the first sentence, the following sentence be inserted. That report shall be made at the next commission meeting, period. Do I have a second?
Second. I also was going to comment on what a great job the executive director is doing, but she wouldn't believe me, so my second.
She always does a great job. All right, any public comment on item 7? Hearing and seeing none, Ms. Contreras.
Commissioner Ortiz? Commissioner Wilson? Commissioner
Aye.
Motion passes.
All right, thank you. All right, we'll now proceed to item 8. That is our legislative update, our, I think, final legislative update from this past legislative session. And joining us is our senior FPPC Legislative Counsel, Ms. Nakano.
Good morning, Mr. Chair and Commissioners. Welcome, Commissioner Ortiz. Can you see me there? There I am.
Yes.
All right. I'm Lindsay Nakano, FPPC Senior Legislative Counsel. Today, I'll give an update on the final status of the remaining commission-related bills. And next month at the November meeting, I'll present legislative ideas for next year for the Commission's consideration. By the end of the legislative session, 6 commission-related bills were sent to the governor. 5 of those bills were signed and 1 was vetoed. I'll go over those bills now in the order that's in the written report that's attached to today's agenda. I'm happy to report that SB 29 by Senator Glazer relating to the Commission's Political Reform Education Program was signed by the governor and as an urgency bill will take effect immediately. The bill codifies the Commission's Political Reform Education Program, also known as PREP. It authorizes the Commission to charge a fee to participants, and it requires filing officers to waive the late filing fee for an individual who successfully completes PREP in relation to that same late filing. As I reported last month, SB 678 by Senator Umberg, adding a disclaimer requirement for paid posts by third parties on social media, was signed by the governor and will become operative on January 1st. AB 37 by Assemblymember Bonta was vetoed by the governor. The bill would have broadened the permitted use of campaign funds for security expenses by allowing expenditure for electronic security systems for candidates, elected officers, and their family and staff, and also for other reasonable costs of providing personal security. AB 334 by Assemblymember Rubio relating to Section 1090 and independent contractors was also signed by the governor and will take effect on January 1st. Section 1090 generally prohibits public officials from participating in making government contracts in which they have a financial interest. In some cases, an independent contractor can be considered a public official for purposes of Section 1090, and the bill clarifies specific circumstances under which an independent contractor is not considered a public official for those purposes. I also reported last month that AB 421 by Assemblymember Bryan relating to listing referendum measure top funders in the ballot pamphlet was signed by the governor and will also become operative January 1st. Last, SB 681 by Senator Allen, shortening the time that PRA bills must be in print before final voting by the legislature, was signed by the governor and will also become operative on January 1st. Prior to this bill, Political Reform Act bills had to be in print for 12 days before final voting by either house. This bill shortens that to 8 days, except for bills that were amended and did not previously amend the PRA. That concludes my update, but I'm happy to answer any questions.
Thank you, Ms. Nakano. Do any commissioners have any questions for Ms. Nakano on the final legislative report for this session? All right. And Ms. Nakano, my understanding is next month you will be coming back to us with our proposals for legislative ideas for next year.
Yes, that's correct.
All right. Well, is there any public comment on this item before we move on? This is item 8, our legislative update. All right. Great job, Ms. Nakano. Thank you for all your hard work this past session, and look forward to next month's discussion about what you'll be busy with next year. Thank you. All right. We'll go ahead and proceed to our executive staff reports. Let's go ahead and start with the Enforcement Division. Do any commissioners have questions or comments for Mr. Lindsay on the Enforcement Division report? Hearing and seeing none, is there any public comment on the Enforcement Division report? All right. Thank you, Mr. Lindsay.
Welcome.
All right. Audits and Assistance Division, Chief Shaw, who I believe is attending remotely. We'll give her a second to appear.
Yes, I'm here.
All right.
Hello, Commissioners. My report is submitted this month, but I'm here to answer any questions if you have any.
Thank you, Chief Shaw. Any questions for Chief Shaw? Any public comment on Chief Shaw's report? Hearing and seeing none. Thank you, Chief Shaw.
Thank you.
All right. Legal Division, Mr. Bainbridge. Any questions for Mr. Bainbridge on the Legal Division report? Mr. Bainbridge, anything you want to point out from your report?
Nope.
All right. Any public comment on Mr. Bainbridge's Legal Division report? All right. Thank you, Mr. Bainbridge. Admin and Technology, Chief Hahn. Well, good afternoon.
Good afternoon. I would like to submit the report as is, but I would like to do a shout out for our IT division of helping out setting the travel meeting here today.
Yes, thank you. That's, thank you for the reminder. Thank you to not just IT, you and Juliana, everyone who participated and from the FPPC in getting this meeting organized and set up. Much appreciated. Thank you guys. And yes. And the Maddie Institute for hosting us, everybody who put this together. Just again, thank you very much. Any public comment on the Admin Technology Division report? All right. Last but not least, Executive Director West. How's it going?
It's great. We're almost done. So I would like to report that, as some of you know, we had a roundtable discussion with local officials, filing officers, clerks, DAs, all came. We had a turnout of about 30 people. It was at the Maddie Institute. They hosted us. It was a terrific location with free parking, which is great. I really appreciate that. And so we went over a couple of things. One of the things the commission's always worked on is outreach about our educational offerings. As you know, our website has a ton of information. So we took a lot of time to specifically show where certain things were and pointed out things like the candidate checklist that we had created a couple of years ago that can help new candidates to go, oh, yes, I have to file a 501, and oh, I'm going to have a committee. That's a 410. And so it was really good. Chair Matich, myself, Dave Bainbridge, Jay Waranga, Chloe Hackert, and Cole Smith all attended for the FPPC. And Cole actually organized the event. So this was his first event for the FPPC. As some of you may know, he's our executive researcher. So when you guys come up with these ideas at commission meetings, he gets those assignments. So, and then we talked about upcoming training opportunities, including the LaVine Act training, highlighting that, and how to request training. Chloe went over how to request trainings and on how we can also work with them to actually manipulate our trainings to add more some of their local flair and their local roles so that it pertains to all of the things they want to talk about. We emphasize the prep program because it was brought to our attention that people aren't really all that aware of our prep program. And when a prominent law firm in this area congratulated Senator Glazer for creating the program for his prep bill, we were like, hold on, we've already been doing this for a year. So we realized we need to do a little bit more outreach on that. So that was something that we learned also from this roundtable. And got a lot of good feedback, talked to them about pre-election and how pre-election outreach works. And they love electronic filing for SEIs. They would love it to be expanded. And they said if we pursue that bill, as you guys will review the legislative proposals next month, that if we pursue it again, that would be something that these city clerks would probably support. So there's 275 of them, I believe, so in their association. So that would be something with legislative support that we might be able to pursue again. And just having a little bit more outreach to the clerks themselves and the filing officers, because we usually go through CSAC in League of Cities and maybe it doesn't trickle down or they receive so many emails. So we talk to them about the mailing lists on our website. And for all of you that don't know, if you want to keep up to date on FPPC information, the mailing list at the bottom of the first page, you can sign up for anything that you're interested in, and it just comes right to your email box. And that includes quarterly updates by subject area, agendas, press release. It has advice letter updates. So it's a really great resource. I use it myself so that I don't miss anything. So sometimes it's just nice to have it come to your email instead of hunting it down. So we promoted that, and it was a really great give and take, and they appreciated us coming to Fresno.
Thank you, Ms. West. Any questions, comments for Ms. West? Thank you. And let me just say again, echoing your earlier comments, thank you to Cole, thank you to you and everyone else who helped and the Maddie Institute for hosting us yesterday at our roundtable, and for all the local elections officials who took time out of their day to come and meet with us and have that discussion. It was really very helpful. Any public comment on the executive director's update? Hearing and seeing none, that brings us to our final item, item 10. This is an opportunity for commissioners to identify future agenda items that they would like placed on the agenda. I have one that derives from the public comment letter that we received under item 1. Part of what that letter is expressing is a concern about how the FPPC has interpreted the phrase "a subsequent election" that exists in Government Code Section 85317. And our existing definition was adopted, if not 20 years ago, quite some time ago. I think it may be that long now. And that's Regulation 18537.1, which defines that phrase, "a subsequent election." And so my future agenda item is a request that Mr. Bainbridge and the legal division come back to us with a couple things. First, I'd like the commission to be briefed on what the commission at the time when they adopted Regulation 18537.1, what was the rationale or the basis upon which they made the decision to define a subsequent election the way it currently is defined in our regulations, including what other alternatives may have been proposed or considered at that time and why they were rejected in favor of the current definition in 18537.1. I would also like staff to identify if there are other ways, other than what was considered previously, if there are other ways that staff believes we could interpret a subsequent election that are permissible legally, but different from how we currently interpret that term in Regulation 18537.1. So, Mr. Bainbridge, I always say, can you just pull this all together for next month? My understanding is that might be a bit of a heavy lift, but perhaps we don't meet in December. But if this is something that you could get together for January, that would be my sense that would be helpful to the commission.
January sounds good.
Okay, thank you. That was my idea. Anybody else have any future agenda items? Commissioner Ortiz?
Just to talk about proposed or just pure comment?
Both.
Oh, okay. I want to make a comment. Thank
Yes.
you. I want to acknowledge the warm welcome that I have received from commissions and staff. I really appreciate it. And I'm looking forward to working with all of you on these very important issues. The second one is I also want to acknowledge your telephone advice. As a former elected official that didn't have some huge question or anything like that, to make that phone call and get somebody to answer the question was so important. So kudos to them.
Thank you, Commissioner Ortiz, and again, welcome. It's really great to have you. Any other future agenda items? Final comments? All right. With that, I will move that we adjourn. Do I have a second? Second. Any public comment? Hearing and seeing none. Ms. Contreras.
Commissioner Ortiz? Yes.
Yes.
Commissioner Wilson? Commissioner Wood? Chair Maddich?
Aye.
Motion passes.
All right. Thank you, everyone. Take care.
Just like President